Clause 14 is about the materials and goods. There are 4 sub-clauses here. The relevant statements are given here. Now let us look at the slides for this clause 14. First, what is materials and goods? It is basically things or items that are to be used or incorporated within the works that eventually going to be delivered to the employers. What are the conditions about these materials and goods? First, the materials and goods delivered to the site shall not be removed until completion of the work. In another word, whichever materials and goods which is related to the work for incorporating into the permanent works cannot be simply removed from the site unless there is prior consent in writing by the architect. This clause is to prevent the dishonest act of the contractors, that the materials and goods being delivered to the site should theoretically be entitled for the payment, which supposedly to be incorporated in the permanent works or to be delivered together to the employer. It is important to ensure that the relevant materials and goods ultimately reach the employers, which is after the completion of the works. Therefore, this clause does not allow the contractors to remove any of those before the completion of the works. However, there could be some circumstances that the relevant materials and goods needs to be removed. For that, the contractors will require the consent in written by the architect instructing to remove those. The request of removing certain materials and goods may come from the contractors requesting the consent from the architect in written so that the contractors is allowed to remove those. Under these circumstances, the architect should not unreasonably withhold or delay the consent. It is so that the progress of the work is not being affected due to the delay by the architect. Next, when the materials and goods has been delivered to the site, it is entitled for the claims. The relevant value may be included into the interim certificate, and the employer will need to pay for the materials and goods as well as the respective works. Now, once the values has been incorporated in the interim certificate and the employer has paid for the materials and goods, now these materials and goods should be the properties of the employer. In another word, before the payments by the employer, the materials and goods can still be considered the properties of the contractor, but once it is paid and it is clearly written in the interim certificate, those materials and goods will be the properties of the employers. Even though these are the properties of the employer now, the contractor should also be responsible for any loss or damage to those materials and goods, including those supplied by the nominated subcontractors and the nominated suppliers. It doesn't mean that once it is in the interim certificate and the employer has paid for that and it is the properties of the employer, it is no longer under the responsibility of the contractors. The site is still with the possessions of the contractors. The following word, if not carefully done, may also incur damage to those materials and goods. The contractor should be liable for that. In another word, now at this stage, technically those materials and goods belongs to the employer, but the responsibility of the well-being of those materials and goods, because it is still within the site being possessed by the contractor will have to take the full responsibilities. This also includes the materials and goods supplied by the NSC and the NS. Next is about the warranties for those materials and goods. The contract deemed the contractors to have warrant for all the materials and goods which have officially applied for payment from the employers. That means the contractor should have already warranted those materials and goods by the time he submit for the claim applications for those materials and goods. The contractor should have cleared all the necessary warranties so that in terms of any damages, malfunctioning related to the qualities of those materials and goods as warranted by the manufacturer, the contractors will release himself the burdens of rectifying those. Simply said, by the time the contractors apply for payment, the contractor should theoretically have the warranty settled, as once it is in the interim certificate and the contractors will be entitled for the payment, those materials and goods will be transferred the ownership to the employer. In the case that the contractors is found to have false warranties, that means the contractor himself actually does not actually get the real warranty. Whichever loss suffered by the employer should be made good by the contractors or should be set off by the employers. That means the contractors is liable for the goods and materials in case of any defaults and defects. In the perspective of the employer, it makes no difference whether the contractor actually met warranties for those materials and goods. If those materials and goods are not actually warranted, the cost will be coming from the contractor instead of the manufacturer, and the employers is entitled to request the contractors to rectify or entitled to set off the cost from the contractors.